Good evening. My name is Cameron Downing, and I'm a civil rights advocate litigator from Washington, D.C. Here today because I need to provide a public notice. This is in accordance with the U.S. Against Rules of Civil Procedure, as well as also Rule 17 and Rule 20 of the United States Supreme Court. The Constitution of the United States of America is the overarching requirements that every state must follow. I think that we would all agree with that. Anybody would disagree. And so states cannot create their own alternative legislation and substitute it for the guarantees of the Constitution. That would be unconstitutional. That would mean that state laws are more powerful than the Constitution of the United States. It's not true. So, Clause 1 of Amendment 5 is certainly part of the Constitution of the United States. It's part of the Bill of Rights. It was adopted and ratified by the people on December 15, 1791, in all intents and purposes. What it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment of indictment or grand jury. That's clear. That indictment by grand jury before arresting someone and holding them over for a capital or an infamous crime. However, the state of Ohio has created its own alternative legislation that permits the prosecuting attorney, police officers to charge by information, not by indictment. That is unconstitutional. So, this is actually reinforced in two different places within the Constitution of the United States. Its first place is Article 1, Section 10, where it says that no state shall create any law that shall impair the obligation of contracts. Police officers, prosecuting attorneys, judges, they're all under contracts. Contracts form. The performance parameters are defined within the Constitution of the United States. And so when the state creates a law that directs them to disobey the law, that would be impairing their obligation in contracts. Now, the second place that reinforces this is the 14th Amendment, where it says that no state shall create or enforce any law that shall impair or abridge the privileges and immunities of United States citizens. The privileges and immunities of United States citizens are, at a minimum, those enumerated within the Bill of Rights, given their legal effect against interference by the states because they're codified in the Constitution's text. Right? So no state can create law that impairs those basic fundamental rights of people. Now, an emolument violation is when you pay someone to break the law. You cannot do that. That is illegal. So I'm here today to provide notice, letting you guys know that I'm litigating this United States Supreme Court. This on behalf of the roughly 700,000 people that are currently imprisoned here in America on direct facial constitutional violations because these states, such as Ohio, has decided to enact this law that permits their prosecuting attorneys, police officers to act unlawfully. You guys pay the police officers' bills. So I'm here today to let you know that we must take a look at Clause 1 Amendment 5, confirm the things I'm saying, confirm that this is true, and then direct your agents to act in a lawful, constitutional manner consistent with the obligations that they have. And if we don't, then there could be criminal sanctions as a result of that. I don't want that to happen, but we do need to understand that we cannot pay people to break the law, certainly not the Constitution of the United States. I have a notice here that I'd like to put on the record, provided to the county attorney as well. But thank you guys so much. God bless, and have a great rest of your night, okay? Thank you.
Thank you so much, Mr. Downing. Yeah, we will take that.
It's the guts and it's the glory. 100 stripes, 100 stories. It's the Pledge of Allegiance on the 4th of July. It's some handwritten letters from home. It's some sleepless nights alone.